Class goes on. All right, guys. I have got 7 o'clock, so I thought we could go ahead and get started. We've got about 9 of you, so we're a little low, but I'm guessing some people will join in as the class goes on. So welcome back to I believe this is our 3rd remote class, but it's our 10th class of the semester. And so basically, we've got a couple of things that we're going to accomplish today. Before we do that, though, I was talking to Dimitri just before everybody got on, and I was saying I kind of wanted to be outside for today's class because it's so nice outside. But I then heard I heard a dog barking, and I heard a lawnmower going. So I thought I better post up in my daughter's room again. So it'll be certainly quieter up here, but I hope some of you have the ability to sit outside on what looks to be a beautiful evening, at least in Lexington. I'm assuming it's the same way in Louisville. So there's that. And one other funny thing is that my oldest daughter said, "You are so loud." She said this to me. She said, "You are so loud when you're talking to your class. I can hear you all the way from downstairs." And I thought, oh my gosh, I hope the students don't think I'm screaming at the computer screen. And she said, "Oh, they could probably just turn you down." And so I suppose that's true. So I hope I'm not being too loud. But I guess you guys feel welcome to turn down the volume if you need to. But I don't know. Anyway, hopefully it's not too disruptive. Okay, so let's talk about what we're going to try to accomplish today. It's pretty straightforward in the sense that we're going to focus a little bit on the drafting exercise that you just completed. And then we'll move forward with the new drafting exercise for next class. We're basically just going to continue the discussion of this top-down format of writing, the bottom line up front, kind of proof-like format that we've talked about from the beginning. And what you did for last class, or I should say in preparation of this class, was an exercise where you drafted an email. And so I want to just talk to some of you about that and kind of how you structure your email. I read over what you all had submitted to me. I should back up a little bit and just say most people got theirs in by 5 o'clock on Saturday. Some people didn't. If you didn't, it's really not a problem. I mean, you're going to want to turn it in if you haven't already sometime soon. But, we're being super flexible with respect to deadlines, just given the circumstances that we're all operating under. So, and the same will go with the next drafting exercise, which is tentatively due this coming Saturday at 5. Again, that's a flexible deadline. If you can't get it done by then, that's really fine. Just, turn it in whenever you get a chance, just so that I have it for record keeping purposes at the end so that, I can check off that you passed the course. So you'll want to make sure that you turn it in. But anyway, most people got it done. There was a wide range, to be honest, of what I got back. Some were super short, and probably would need a lot more detail if it was a substantive email that you were submitting to either a senior associate or a junior partner, some sort of supervising attorney. Some, I think, were a little bit more extensive and kind of had a little bit more of the content that I was looking for. But the goal, I think, here is really to kind of think about the structure of the document, of the email correspondence, and also some of the information you would want to include. So I thought I might call on one or two of you and just kind of see how you added some structure to your assignment, how you structured it, how you formatted it, and then maybe talk to somebody else a little bit about how you, what sort of substantive information you included. Okay, so let's start with, I don't know, does anybody want to raise their little purple hand here and help me out? Nobody has to volunteer, but if somebody's interested in volunteering, and kind of let me know. No volunteers yet. How about, let's see, what about, how about Alexander? You're the first one on my list. So can you kind of jump on here and walk? Can you see me and hear me okay, Alexander?
Yeah, I'm here. Can you see me?
Okay. Yeah, I can. How's it going? So you got a good setup. You look outside. It looks sunny there. You look like you've got one of those heaters. Is it keeping you warm?
I don't have a heater. I apologize if the dogs are barking in the background.
No, you're fine. I can't hear the dogs at all. Is that thing that's behind your left shoulder not a heater?
No, it's just like a storage container.
Oh, that's cool. Because, the reason I'm making this an issue is because my wife wants to get one of the. Do you know what I'm talking about? Those portable heaters that go on the back deck?
Yes.
So we're in the market for those. So I was kind of sensitive to that. Anyway, it looks nice. Are you in Louisville?
No, I'm back home in Columbia, Kentucky.
Okay. And the weather's nice there. So you're enjoying some outdoor time. All right, well, let's chat. What did you think about the email? I mean, how would you... Let's talk about how you structured it. I mean, what was your kind of format? How did you set it up?
So I started off with an introductory paragraph that just kind of said basically, here's my final conclusion, and then basically introduced the 4 elements that had to be satisfied. And then from that point, I separated the headings into the 4 elements, basically giving the conclusion of the 4 elements of each heading, and just kind of discussed each of the elements. Some of them were longer than others, obviously. Like the first 2 were obviously pretty short, but
yes.
But 3 and especially 4 were longer.
Yeah, but that's exactly right. I mean, I think that's what we were looking for. It's interesting. Some students it was a very quick, the entire email may have been a paragraph or 2. But really, man, that's not what you did. I think what you're talking about is exactly what I was looking for. More of kind of a lengthy, substantive discussion where your first paragraph is that kind of almost thought of it. We call it bottom line up front, proof top down. But the first paragraph really is kind of an overview of where the entire email is going to go. And I think, especially in email correspondence, when you're thinking about informing and persuading, a lot of times with a senior associate, junior partner, senior partner, somebody in a position, or a judge that you're working for, somebody where you want to kind of say up front, hey, this is what the answer is and why it is what it is. A lot of times when people are going back and referring to an email again, they might not read much past beyond the first paragraph. And so you want to say up front, look, hey, if you know that the question is, and I'm just scanning over the document again, if you need to know, if Larry needs to know whether or not Maria is a strong candidate for cancellation of removal for non-permanent residence, your first sentence ought to be an answer to that overarching question, that 10,000 question, which is, for example, Maria is a strong candidate for cancellation of removal for non-permanent residence, period. Second sentence, that is because she meets all of the statutory elements for that form of relief under the Immigration and Nationality Act. And then in that same paragraph, I think you'd want to basically provide 4 subsequent sentences with respect to each of the elements. And I think that's what you did. Well, remind us what the first elements were.
I've got it pulled up. The first one is the person must have been physically present in the United States for 10 years. And then
exactly.
The person can't be convicted of any crimes.
Yeah, so I think the way to do it in your first paragraph is basically to just set it up where you would turn those points of law into just affirmative statements about the individual in question. So you would just say, Maria is a strong candidate for cancellation of removal for non-permanent residence, period. That's because she meets each of the 4 statutory elements set forth in Section 240A of the Immigration and Nationality Act, period. First, Maria has been physically present in the United States for a continuous period of at least 10 years immediately preceding her application for cancellation of removal, period. Second, she's not been convicted of any crimes, period. Third, she's been a person of good moral character. Now, there's more detail in that 3rd and 4th element, but I think for purposes of the first paragraph, you just want one sentence, kind of quick and dirty, hey, she's got the good moral character. And 4th, she, her child would suffer exceptional, extremely unusual hardship. You're going to want to get into more detail down below in the email in those subsequent paragraphs. But I think it's sufficient just to say in the first paragraph, hey, these are the 4 elements and she meets them. And then I think, and you used headings, it sounds like, Alexander, is that right?
Yes, I did.
Yeah, I think that works here. I mean, I think jury's kind of out on that. I mean, that's open to debate. I mean, I definitely think the minute you get into kind of multiple elements of a cause of action, it never hurts to have, headings where you say physical presence, criminal convictions, good moral character, exceptional and extremely unusual hardship. I think the challenges can become, there are a couple of things that come to mind. One is you want to make sure, especially when you're talking about an area of law that you may not be familiar with, like immigration law, you want to make sure that your headings kind of are the right buzzwords. And here I think it would be things like physical presence, convictions, good moral character, and exceptional, extremely unusual hardship. But sometimes students are, not just students, but also practitioners can be uncertain as to whether the headings that they're putting forward accurately capture the element that they're discussing. And so I guess what I would say is, to the extent that you're unsure that you're using the right buzzwords or the right words in the heading, then you might avoid it. But if you feel like you've got a good handle on it, I think it can be good. The second thing about headings is sometimes it can make the document, whether it's an email or a memo or a judicial opinion, it can make it a little hokey if you've got, that's a very official term, by the way, hokey. It can look a little hokey if you've got a heading and then not a lot of content. Like if you've got physical presence and then you've got just a couple of sentences under that, and that's it. That's your whole analysis. So I don't know. I'm a little torn on whether headings would be helpful here. The critical thing is, whether you include them or not, I think the format is the same. First paragraph with the thesis, and then what I'm envisioning, and some of you had this, some of you didn't, I'm envisioning at least 4 subsequent paragraphs with one paragraph tied into each of the elements. And I think you're right, Alexander. The first one is pretty straightforward. I think you'd want to start that first substantive paragraph. It would be your second paragraph in your email, but it would be the first substantive paragraph, again with a bottom line up front, saying, first, Maria has been physically present in the United States for a continuous period of at least 10 years immediately preceding the date of her application for cancellation of removal. That's the answer, and then you would want to explain why. That is because she entered the United States on this date, and insert the date, period, and she didn't, and that being said, she didn't apply until this date. Thus, more than 10 years have passed, or at least 10 years have passed from the date that she entered the United States and the date that she applied for cancellation of removal. And then to a conclusion or a button-up sentence at the end of that paragraph would be something like, thus the first statutory element is met. You see that? So it's just little proofs, just very straightforward, like you give your answer. The thesis is your overarching answer, your kind of 10,000-foot view, and then your sub reasons why that overarching answer is correct. So it's basically just restating the 4 substantive elements in a direct way that applies to Maria, and then having 4 separate paragraphs for each of the elements of the cause of action. And so here, the first element, you would want to do a little proof. First she meets it, and here's why. Thus, she satisfies the first element. Second, and you could say, now we're in the third paragraph, it would be the second substantive paragraph. Something like, second, Maria has not been convicted of any crimes. Indeed, the facts make it clear that outside of arriving in the United States without inspection, she's not been convicted of any crimes while she's in the United States. Thus, she meets the second element. All right, now here's a question, Alex. I think that's all pretty straightforward. What did you do with respect to the third element? Because there's a lot more detail there. How did you answer your third element in your email?
So there were those 3 factors that were provided. There was dependability in the workplace, the commitment to spouse and children, and a respectful attitude towards others. And I kind of briefly went over each of those factors and provided examples of things that kind of showed that she was dependable in the workplace. She is committed to her child, Billy, I think, and as respectful attitude towards others. I think there was a sentence that was like, even DHS said, she's the kind of person anyone would love to have as a neighbor. And
yeah, exactly. Yeah, this is a good client to have if you want to do respondents work. I mean, this is a good fact pattern for Maria. You know, it's interesting. The reason why I put this in here is because there will be some moments when you are, you know, sending an email, writing a memo, drafting an opinion, where you're going through these elements and you're doing these kind of proof-like paragraphs. And every once in a while, you'll get one where you kind of have to explain a little bit what is going on with respect to that paragraph. And so the way you would start that sentence, that third substantive paragraph, which of course is the fourth paragraph in your email, right? The first one is the thesis, and you've got second paragraph is the first substantive paragraph about physical presence. And you're on the second substantive paragraph, which is about criminal convictions. This is the third substantive paragraph. And I think you'd want to start out in the top-down way, say something like, third, Maria has been a person of good moral character for the 10 years immediately preceding the date of the application for cancellation of removal. But normally, I've always kind of taught you all, like you would immediately then want to prove why she's been a person of good moral character. This sounds like I'm going to backtrack a little bit, but I think there are moments where you do want to kind of explain the law a little bit, right? Because if you just dive into things like dependability in the workplace, a commitment to spouse or children, and a respectful attitude, a reader might wonder why you're talking about those factors under good moral character unless you explain to the reader, hey, these are the relevant factors. So I do think that this is an example, and I think, frankly, the next element is also an example where you can state the bottom line up front, but I do think you have to then come back a little bit and then explain why you're doing what you're doing. So what I would say is something like this. New paragraph. Third, Maria has been a person of good moral character for the 10 years immediately preceding the date of the application for cancellation of removal. To be sure, the Immigration and Nationality Act does not specifically define good moral character. However, in matter of Sanchez-Lin, the Board of Immigration Appeals has said, blah, 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 blah. These factors should be considered. Then I did an applied to these facts, and I went factor by factor. And so it's a little bit of conclusion. Then you do have a substantive block of law, and then you have an analysis. But the reason why I think it works here is you do have to back up and give your reader some sense of the landscape on what the elements are that you're talking about, what the factors are you're talking about. See, in the first and second elements, you don't need to give any background statement of the law because it's already clear to the reader what you're analyzing. With the third element, you've got to get into factors that go not beyond good moral character, but they're factors that explain why good moral character is what they are. So this is a situation where I think you want to do the bottom line up front, but I do think you have to then give at least some sort of discussion about law with respect to the factors and then analyze those factors, which makes it feel more like a fact pattern that you would resolve in maybe like a law school exam or the bar exam or kind of like the issue rule analysis conclusion. Does that make sense?
Yeah, I totally understand it.
Okay, all right. So that's how I did it. And then I went factor by factor. And there are a ton of facts. I mean, the goal of this, and some people got this, I think some of you maybe didn't. The goal of this was for you to kind of go through the fact pattern and pull out facts that were relevant to each of those elements. So, and I think you mentioned this, Alexander, which is that there are a lot of these facts that were put in the fact pattern that are relevant to dependability in the workplace, relevant to commitment to his or her spouse and children, or her spouse and children. Here, I think it was her child, and her respectful attitude towards others. Also, it's possible, depending on the extent to which you have a lot of facts to discuss, you might be in the world where you've got extra paragraphs, right? Like, don't be afraid to have a paragraph just on dependability in the workplace if you've got a lot of facts about that. Don't be afraid to have a paragraph about commitment to spouse or children if you've got a lot of facts about that. don't be afraid to have a whole paragraph about respectful attitude towards others if you've got a ton of facts. You don't want a massive paragraph and just say, well, because it all refers to one element, I need to have one in each paragraph. You really don't. You just need to make it clear up front. Hey, we're talking about good moral character. Here's what it means. Here are the factors we're going to discuss, and then I'm going to apply these to the facts and go factor by factor. Does that make sense?
Yes.
Okay. That's what I did for the fourth one, too. Same thing. Like, that was even more detailed. You almost certainly are going to have multiple factors. But I did something like, fourth, Maria can establish that her deportation from the United States would result in exceptional and extremely unusual hardship to her United States citizen child, period. So there's my bottom line up front. Now, except you guys don't know this because most of you, I don't think anybody has taken immigration law. Exceptional and extremely unusual hardship is a term of art in the law. It's very much like a specific phrase that has a concrete meaning. And in order to convey that to the supervisor that you're sending the email to, I would back up and say, it's worth recognizing that term means this, and then lay out what the legislative history says, lay out what the matter of Racina's case says. So you will have a block of law there, but it's all for the purposes of explaining what that term means, and then you're going to go factor by factor through family ties, length of residence in the United States, ties to the community, health and medical conditions. But it's all within this top-down format of going through the elements. So nobody's losing sight. No reader is losing sight of what you're discussing, right? They know, hey, this person, this writer is analyzing this fourth element. They've told me up front Maria meets this element. Now they're just explaining to me why she meets it. They're explaining to me what the element means and why she meets the factors in those elements, in that element. Does that make sense? I feel like now I'm yelling. My kids are probably rolling their eyes downstairs like, he's yelling again, Anyway. Okay, that's what I wanted you to do. Any questions about that, either Alexander or anybody else? I think what I wanted to... Thanks, Alexander, for your help. That was great. Some of you got that. I think that there was a lot of the submissions I got, frankly, were shorter than what I would have expected, and maybe were just like one or two paragraphs. And I think I may have kind of suggested that it should have been shorter than I wanted it. I mean, I certainly didn't want you to write an essay, a 20-page email. But, I would have at least expected 5 paragraphs. And you might think about this if you have to go back and edit this for the final portfolio. You'd want at least 5 paragraphs. 1 thesis paragraph, and then 1 paragraph for each of the substantive elements. And you want to think about making the thesis top down, bottom line up front, and then each of the elements top down and proof-like. And within each element, if you have to explain what a term means by going in and having a little chunk of law or a little list of factors and then applying those factors to the facts of the case, I think that's okay. That's a little bit of an exception to our rule where you don't want chunks of law. You don't want chunks of law because, as a general matter, huge chunks, because it's oftentimes hard for the reader to follow what you're trying to say. They just get lost in standards of review and huge chunks of law. But if they know up front that Maria is a person of good moral character, and if you're just saying, hey, let me explain quickly what that means and what factors are relevant, I don't think that's too much for the reader to hold in their head. And it stays true to this same kind of top-down, bottom line up front format. Okay. All right. Well, I hope that makes sense. And I hope it makes sense in part because it's really the same skill that we're going to talk about with respect to the next assignment. So let's really just move from this drafting exercise to the next one, because I think we're just going to kind of, go through the same lesson or try to pull out the same kind of lessons for this new exercise that we did for the one that you just completed. So raise your hand if you were able to locate the new drafting exercise on TWEN. Were you able to find that? Okay. Looks like most one. Keep raising your hand. Make sure that you can locate. Okay. Seems like most of you. Okay, I'm going to look right now. Okay, good. Yeah, go look. If you haven't looked already, go look on Twen. Basically, and there's going to be no new formal reading assignment for next class because I kind of made the new reading a part of the exercise. So if you can, while you're on here with me, go to the Twen site and go to the drafting exercises tab. I, of course, have updated the syllabus to reflect what we're doing in today's class. If you go to the drafting exercises tab and look at the drafting exercise folder that says it's due by Saturday, April 11th at 5, there are 3 PDFs. There's the actual assignment, the drafting exercise, which is a judicial opinion. Then there's a short, about 10-page article called Informing and Persuading Judicial Opinions. And then there's actually a judicial opinion called Watson versus McLean. So if you can, go there and pull up the actual assignment first. It's the first PDF entitled Drafting Exercise, and then Judicial Opinion is in a parenthetical. It basically says, look, read the article titled Informing and Persuading Judicial Opinions, then read Watson versus McLean, which is a federal district court opinion out of the Northern District of Ohio from 2014. And then the drafting exercise is to rewrite the opinion to make it easier to understand and more persuasive. And it says, in doing so, please draft the opinion in the top-down, bottom line up front, proof-like manner we've discussed. Now, let's quickly open up just for a minute the article. We're not going to spend a ton of time talking about this yet, just because I kind of want you to read it first. The article is just something you can skim. I mean, the point of this is to really kind of give you a little bit of a sense of how judicial opinions are written, what the structure of them look like as a general matter. You have discussions of facts. And then, first you kind of have a bottom line up front thesis-like statement. You've got a discussion of facts, and then you've got an analysis of law before coming to a conclusion. Page 354 of that PDF, I think, kind of accurately lays out the components of a judicial opinion. The only kind of caveat there is if you look on that PDF, page 354, I think it's maybe 5 or 7 pages into the PDF, it has this statement of issues section. I don't think that that's something you need. Generally, it's no different than any other kind of, substantive piece of writing. You're going to have this bottom line up front kind of thesis-like paragraph, just like you did in that email, and then you'll immediately move in a judicial opinion to a fact section, which is a little bit different. You didn't have that in your email, but then you're going to go straight into the analysis, which is going to look kind of a lot like your email did, which is the bottom line up front, and then you're going to have like little proof-like paragraphs. And we'll talk about the opinion from the Northern District of Ohio in a minute, the one that you're going to rewrite, because I think you'll kind of get a better sense of what I'm looking for in a minute. But it's really pages 354 to 357 of this article that I think are the best and that I would focus on when you're reviewing it, because I think it best discusses the components of a judicial opinion, which is what I want you to focus on. Any questions about that? Raise your hand if you, Anthony, it looks like you've got your hand raised. Do you have a question or a concern?
Oh, no, sorry. I just didn't.
Oh, no.
From the your last question.
Were you able to locate the?
Yeah.
Okay.
I have located that. Yeah.
Cool. Okay, that sounds good. All right, so let's look. So we've got so what's the drafting exercise? The drafting exercise is to read this article on judicial opinions, 10 pages or so. And then let's take a look at this Watson versus McLean, because that's what you're basically going to have to rewrite. Now, when I did this last semester, I got a whole range of things, from edits to this opinion, like almost like kind of red line edits, like somebody printed it off and then kind of edited it with a pencil, and all the way to some students who it was almost as if they just kind of discarded the opinion and started fresh. I'm kind of looking for a balance somewhere in between those two things. I'm definitely looking more for a rewrite than an edit. I mean, what you give me should definitely not look like what is in this opinion currently, in part because this is way too long. Like, I do not want most of what's in here. And yeah, I should back up and say this. Like, I definitely want to be humble, right? I mean, I'm a visiting professor at Louisville. You know, this is a federal judge who wrote an opinion. I'm in no way kind of suggesting that it's poorly written or that it's not a good opinion or that I don't agree with the analysis. But the point here is that part of the reason why I kind of feel comfortable critiquing this is a pro se case, meaning it's a case filed by a pro se litigant who's challenging the conditions of his confinement, which means that this decision was probably written by someone who does the same job that I do. Now, it's, of course, signed by a federal judge, so it becomes the judge's opinion, and that's just true for any clerkship. But I think it's written consistent with something that my own office in the federal courthouse would produce. And frankly, and again, it's, you know, our discussion kind of stays within our class and it's for academic purposes only, because it's not a criticism of the judge in any way. I would not even dream to criticize a judge's writing. But I do think the point of this is the opinion is written in very much a template kind of style. And I think all you have to do is kind of pull that up to read this, or pull the opinion up to kind of see this. So take a look at it if you haven't pulled it up yet. It's Watson versus McLean. And it's very template-y, right? You've got a background and a history, and we'll go through this in more detail, but let's just skim through it. And you've got a standard of review, which has it looks like maybe 2 paragraphs, 2.5-ish paragraphs of just what look honestly like just copied and pasted law about the standard for pleading in pro se cases. Then you've got an analysis section, and now you're thinking, oh, like, this is going to be good. This is going to, like, get us into kind of the facts of this person's case. But what you quickly see is, like, you've got a little bit of a paragraph about what the plaintiff is asserting, but then you've got this whole discussion about the Eighth Amendment. And really, that second paragraph under analysis is not only massive, but it's not really analyzing anything. It's just a huge chunk of law. Then you go to the third paragraph, and it's even more law. It's just all law. And then you go to the fourth paragraph under analysis in the context of a claim, and it's just law. It's pretty much all law, except for the very last sentence or two, where the judge says, interestingly, in the first person, which is not, I don't see that often, but the judge says, I must first determine whether the plaintiff's medical condition is sufficiently serious. My point here is that it's very template-y. It's a lot of blocks of law. It's a lot of just statements about, it feels like a lot of paragraphs that, frankly, were just copied and pasted. And it's certainly not in this kind of top-down, bottom-line, up-front proof-like manner. What comes across here is that there's some sort of Eighth Amendment claim that the prisoner is making about the conditions of his confinement, and what the court is going to do is say, hey, here's what the case is about, here's the standard of review, here's all the law that may or may not be relevant on Eighth Amendment, and then we're going to apply that law to the facts and come to a conclusion. So it reads very much like a template that you would see in a lot of cases, but also something that you might see in an answer to a law school fact pattern. Okay, so all of that said, now this is going to be an interesting discussion. Why might this be an effective way to write the opinion? Like, it's not what I would do, but what is the benefit of doing it this way? Who's got a reaction to that? How about Meredith? Any reaction to that?
I mean, not really. I think it makes sense just to go that way, though. So, I mean.
Well, but why would you want to draft the opinion this way in this, issue rule analysis conclusion with huge blocks of law, huge blocks of, statements regarding the standard review? Like, why draft it this way?
Well, I mean, when I say it makes sense, I mean, it makes sense from the sense of, teaching purposes. In reality, I think it's annoying, but if it's, I feel like the majority of stuff we read in our case books is done so that way we really learn what the rule is. So in that regard, that draft would make sense. But if it's something that's never meant to be formative law that you're teaching, then yeah, no, that's boring and no one wants to read it, if we're being completely honest here.
Well, no, I think that's good. Okay, so you've got one really good kind of persuasive reason for why this opinion as written, I mean, we haven't read the whole thing, but one argument in favor of this format of drafting is that it's beneficial to litigants who may be looking at this down the road and doing legal research. And I think that's true, right? Like if you're somebody who's looking for law on the Eighth Amendment, this is a good case for that because I think you've got a lot of clear articulations of law. Okay, so that's one, Meredith. Let's go to somebody else. That's good. What about Leanna? What do you think? What's another benefit of doing it this way as opposed to the top-down kind of bottom line up front way?
So I feel like it is creating a good foundation with all the law of these are all the reasons why I'm correct.
Okay. You mean expand upon them?
Well, I agree. It's a very extensive list of case law that is provided. And I feel like that is good support for, I don't know, I guess maybe we're so, like Meredith said, I think we're just so used to seeing it that way in school. So we're like, oh yeah, that seems right.
I think that's fair. I mean, put yourself in the shoes of the law clerk who's writing this, okay? Let's say you're a law clerk and you're drafting an opinion in a case like this. Why might this be a good way to draft it?
I honestly don't know.
Well, that's okay. That's okay. Who can help us out here? Let's see. Somebody raise their hand if they can't. Okay, Kirby, what do you think?
Okay, see my video will work this time. It hasn't. Okay.
Yeah, it looks good. I heard the birds chirping, so I knew before the video started that you were outside.
How do I go back inside? I'm not sure what the background noise.
No, it's not bad at all. It's fine. It looks peaceful out there. Okay. Good.
Yeah, the sun went down, so you can see me now. So I just sun. But I think that probably the purpose behind this is just making sure everyone knows the point you're trying to make and supporting it with the law, so there's no holes. So if someone comes back trying to refute it, it's a district court case, so it could get appealed to the Court of Appeals. So I think that possibly, and also you're restating the precedent from your court and your circuit, so it's clear. And I think that maybe they took the opportunity to be able to do that, and I may just what audience they're expecting to read this probably matters. Are they expecting people to cite this for the Eighth Amendment or whatnot? Or do they just want it to be convenient for a judge to read it? I think that probably has a lot to do with it as well.
Yeah, I think you've got a lot there. I mean, I definitely think you're right. People could pick it up and take a look at it. You said something that I want you to expand upon a little bit, which is this idea of you as the drafter are relying on a lot of case law, presumably either from your court or from the circuit. And I think that's true. I mean, if you look at the opinion, we haven't read it yet in any detail.
Yeah, they're all Sixth Circuit cases, or
a lot of Sixth Circuit cases. There's certainly some case law cited from within the district, and maybe even from other districts in the circuit.
Mm-hmm.
But tease that out a little bit. I mean, and think really practically. Like, you're the law clerk, and trust me, like, this is just one. I just got 2 new cases today when I was in my job. Like, think of the clerk who's busy and has a lot of cases. Like, what's the benefit of doing it this way?
I feel like if it were me, like, maybe they're new and they're just wanting to make sure, like, they've done a thorough job of supporting the decision that was made. I can see myself doing that. I guess, I don't know, maybe they don't want to be, like, left in any polls where they miss something. Like, it seems a bit excessive, like, you probably need to cite that many, but I obviously haven't read it, so I'm not sure if it's a contentious issue or not, so maybe it's important to cite this many just to support what it was. I'll have to read it to...
Yeah, no, it definitely comes across as very comprehensive, for sure. I mean, that's good. You're not wrong. You're totally right about that. I'm thinking, like, super practically. Like, you know, if you've got huge chunks of law here that just sound like boilerplate, right? Like, it might be very well-written boilerplate. Like, it might almost be a shorter
argument section because you've already proved it, so you say because of this, and then you don't have to spend as much time maybe doing that because you've just written the law.
Well, that is my point. I think you got there, which is that it's really easier, isn't it?
Yeah.
Isn't it real? I mean, I think somebody's got to build up the boilerplate, right? Like, somebody's got to start like a template. But you know, for most of us, and it's true for me, and I'm sure it'll be true for all of you when you start your first job, like, you're going into a job with, like, it's usually not a job, whether it's at a firm or a government agency or a business. The business may be a little trickier because you're in-house and you might be doing more on your own, but there's always a shared drive, right? There's like old opinions that have been written. Like, when you're fine. The dog's fine. When you go draft an opinion, you're gonna, like, pull up old opinions that were written. You draft an email, you might, like, talk to the other associates that you just got a beer with and say, hey, like, I got to send Barb an email, and I heard she, you know, really wants detail. What did you say when you sent Barb an email? Or, you know, or you'll pull the shared driver, or, hey, you have to draft a complaint. Like, you're not just, I mean, I love this class, but you're not just going to, like, pull out your legal drafting notes. That's not going to be your first place. What you're going to do is pull out, like, an old complaint that your firm drafted. And so this reads like that. This reads like, hey, this is another Eighth Amendment case involving a prisoner. Let's copy and paste all of the law. Let's copy and paste the standard of review and just jump to the analysis section, right? Kind of like if you take an open book law school exam, you might, like, start typing. You might say, like, the issue in this case is whether or not the new city ordinance runs afoul of the First Amendment. Under the First Amendment, and you might just type like hell what is in your Constitutional 2 outline about the First Amendment. And you'll then, after you type it all out, either from your memory or from your notes, if it's open book, then you'll have to say, apply to these facts, and then you'll start going back to the fact pattern, and you'll start pulling facts and looking for things to throw into your analysis. That's how you take law school exams. That's how you take the bar exam. And that seems like how a lot of lawyers practice, and that's how a lot of judicial law clerks write, and that's how a lot of judges, what they sign off on, and maybe how the judges want you to write. And if the judge wants you to write that way, then that's the way you should write it. It doesn't matter what I said. I'm just some guy who teaches a night class online now. But what I'm trying to argue here is it's easier to do it that way, but it's less persuasive, I think. And I think Professor Bahens thinks so, and I think the body of legal drafting scholarship that's out there is starting to realize, you know, that may inform to some extent, but it's less persuasive to the reader, and it's not as easy on the reader, right? When you think about an opinion from the reader's perspective, think of all the work they have to do to go through all of this. So good. That was very good, all of you. Kirby, great. Everybody else, you did well as well. But let's go back and look at this. Let's now look at Watson versus McLean in a little bit more detail, and let's think about how you can kind of rewrite it and at first kind of trim it down. I think there's a lot you could just cut out, and then how you would kind of rewrite it. And so let's look at the opinion. If you look on page 1, in this background in history, it gives you a little bit of the background, right? It says pro se plaintiff Ernest Watson filed this action against the North Central Correctional Complex healthcare administrator, Mrs. McLean, another administrator, another person. I don't know that you need to list all of these at the beginning. You could just say he filed an action against multiple prison officials, and then said, in the complaint, he alleges that the defendants have not successfully treated his skin condition. He seeks monetary damages and a referral to a dermatologist. And so you're saying, okay, like he's in prison, he's got a skin problem, and he wants damages. And then the next paragraph says, look, he contracted a skin infection in May of 2012. He signed up for sick call and was referred to see a doctor. He claims that the treatment was ineffective. He goes back to sick call. They give him a lotion. They give him a medicated shampoo. He sends this written request, on and on. These are all facts, most of which I think are going to be relevant to your discussion. His skin condition improves, but then it comes back. This is now kind of on the top of page 1 on the right side. He says he's diagnosed with vitiligo. He disputes the diagnosis. He's prescribed more drugs. He's given penicillin, hydrocortisone cream, blah, 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 blah. Okay. So then you've got the standard of review section, which I don't know that most of that is relevant. What's he arguing, though? Look at the analysis section. It says, as an initial matter, plaintiff does not specify a cause of action he intends to assert in his complaint. Well, that's not altogether rare because a lot of prisoners, and this is understandable, they're pro se litigants, they're incarcerated individuals, they don't have the access to the law that certainly we have as lawyers, and they just don't have the background in it. They just know, hey, I've got a medical condition. I'm complaining about the way it was treated, and I think that's a problem. Well, what the court kind of gleans here is like that's potentially an Eighth Amendment claim, right? The Eighth Amendment prohibits cruel and unusual punishment. And you should read all of this law, even if you don't end up including most of it. The point here, the big picture point, is that the Eighth Amendment prohibits cruel and unusual punishment. And courts have interpreted that to mean that under certain circumstances, prisoners could have a cause of action if they meet 2 elements. And this, believe it or not, after all of these paragraphs, none of this is clear until really 1, 2, 3, it looks like 4 paragraphs into the analysis. But 4 paragraphs into the analysis, you see, it says, in the context of a claim regarding medical treatment, an inmate must show 2 elements to demonstrate a violation of his Eighth Amendment rights. 1, that he was suffering from a serious medical need. And 2, that prison officials were deliberately indifferent to the serious medical need. Okay? So now, of course, those elements need to be expanded upon. But this whole case is somewhat like, I mean, it's not the same in any way factually as Maria's cancellation of removal case, but it's the same idea, right? Which is that you've got a person, something happened to them, here's some facts about what happened, and here's the claim for relief. In this case, the facts are kind of at the beginning in that little background section, and you want to clean them up and kind of tighten them up a little bit. But really, the whole analysis is whether or not the plaintiff has successfully pled the kind of facts needed to make out an Eighth Amendment claim of deliberate indifference. And what are the 2 elements? Serious medical need, and that the prison officials displayed a deliberate indifference to that need. And so you're going to have to analyze that. That's your bottom line up front. So what's your, all of that said, Dimitri, all of that said, what's your first paragraph going to be? I mean, you haven't even read this, and you should know what your first paragraph is going to be. You want to jump in and help us? Dimitri, are you there? Let's try somebody else. I don't know that he can hear me. How about Amy?
I'm sorry, can you say that again?
Yeah, I was just saying, like, in light of what we kind of pointed out, which is that the prisoner is going to have an Eighth Amendment claim here, and that in order to prove up an Eighth Amendment claim of deliberate indifference, you've got to meet two elements, that you suffered a sufficiently serious medical need and that prison officials were deliberately indifferent to that need. What is your first paragraph going to look like of this opinion?
Are we talking about the first paragraph in the analysis or the first paragraph of the whole opinion?
The first paragraph of the whole thing.
So the first paragraph would state that this is a case about an Eighth Amendment violation of cruel and unusual punishment. To meet it, it requires two elements. Would you do it sort of like the email?
I would do it a lot like the email. I think you might need a little bit more at the beginning. You might just have to say, look, Ernest Watson is incarcerated at the North Central Correctional Complex, a prison in northern Ohio. He sues multiple prison officials and claims that those individuals provided him with legally inadequate medical care in violation of his rights under the Eighth Amendment. Okay, that quickly just gets you in as a reader and says, hey, like, big picture, 30,000 foot view, that's what this is about. And then I would immediately give my answer. I would just say something like, Watson has failed to state a claim under the Eighth Amendment, period. That is because Watson has not demonstrated that he was suffering from a serious medical need, period. Moreover, even if he were suffering from a serious medical need, he has not alleged that prison officials were deliberately indifferent to that need. Do you see that? Like, you want there's your, just like the email, the bottom line should be up front. You may need a couple of sentences of background just to orient the reader. Hey, what we're talking about is a guy who's incarcerated in prison in northern Ohio. Who's he suing? Some prison officials. What's he claiming? That they didn't provide him with legally adequate medical care consistent with the Eighth Amendment. Here's why his claim fails. Now, you might read this and say he's met the elements. I don't think he has. The court doesn't think he has. And frankly, although I want you to rewrite the opinion, I don't think you should come to a different conclusion than the court has come to. That's not me passing judgment on the claim. I just think, I think the analysis is correct as a factual matter. I think the cases have probably been shepherdized. I think the analysis holds up. I mean, I haven't frankly looked to see if the Sixth Circuit affirmed it, but I think the case is on pretty solid footing as a legal conclusion goes, and in part because I see a lot of these just in my own job. But the point here is that the structure should look totally different. Really, you want to start with something like that thesis-wise, and then once you have that, Anthony, how about you? Let's go to you. Once you've got that thesis, what are you going to have after that? What's your next section going to look like? Any idea? Anthony, are you there? You might have to put some back.
Yeah, sorry. You're still referring to the opinion, right?
Yeah, I'm basically saying, you've got this, and you haven't read it all, but I want you all to kind of think about how you're already going to structure this thing. Your job is basically to take this opinion, recognize, it's legally right, but, and again, not a criticism of the court in any way, it's not the best written opinion. It's pretty poorly written, I think, because it's very just issue, tons of law, analysis, conclusion. And I'm saying what you want to do is up front have a quick thesis that says, hey, 10,000 foot view, this is what's going on. You got a guy in prison. He's suing prison officials. He's claiming that they're providing him with legally inadequate medical care. And here's why his claim fails, right? His claim fails because he hasn't stated an Eighth Amendment claim, and that's for two reasons. One, he hasn't demonstrated that he suffers from a sufficiently serious medical need. And that's probably true, right? Because he's only suffering from what sounds like a relatively minor skin condition. I mean, not making light of skin conditions, but it's certainly not the type that I would imagine it being sufficiently serious. And two, at least under the Eighth Amendment, And two, even if he did have a serious medical need, he hasn't demonstrated that prison officials displayed a deliberate indifference to that need. If that's your thesis, my question to you, Anthony, is what's your next section of the
You kind of cut off towards the end of that from what I think I heard, but I think after the thesis, I think I would just want to run back through the test as an initial matter for my analysis. After I say basically where I'm going and headed, I think I would want to start back from where my analysis started.
I think in an opinion, the only difference here, though, can somebody help us out? I mean, I think you're right. You're going to want to kind of go back and do your analysis, but does somebody else have a thought on like what you might want to include after your thesis in a judicial opinion? Well, let's go back. What do you think, Kirby? Let's go back to you.
After that, I guess I would just say, after you said, he has not satisfied his claim because he hasn't met the elements, then I would say he hasn't satisfied the first element because of, I would say what it was and then say why he has not met the requirements of that, I think, is what I would do. And I'm not sure what order I put the law in to support it. I don't know if I would say that, like, say he hasn't met it and then maybe state supporting law, and then I don't know how I would organize that, honestly.
Yeah, let me see. Okay, now I want to see. I think I need to explain this better. Let me see if there is the little whiteboard setting. Kirby, talk to me about how I get the whiteboard on here. Do you know how I do that?
Well, that's a great question. We'll figure it out together.
Okay. Does anybody know? Because I want to type this out. I wish I had. See, this is where if we were in class, I would go to the whiteboard and I would start drawing or writing words. And okay, share blank whiteboard. Let's just do that. Okay, can you all see this?
Yeah.
Okay, I'm going to go do text. I'm going to go right here. Okay. Here's the way you need to format this thing, guys. Your first paragraph is going to be let's say Colin is calling the thesis, okay? Now, why do I say Colin is calling the thesis? It's because, this already looks insane. And then it said my battery's low, so I'm going to have to plug my computer in. Okay. I'm calling it the thesis because it's a little bit more than that. Right? Like, what are you going to include in there? You're going to include what I would say is like a 30,000-foot overview of the case. And what do I mean by that? What I mean by that is you're going to have something like Watson, whatever his name is. I should go back. Let me look so I don't get that. What is his name? His name is Ernest Watson. Okay, so it's something like Ernest Watson. I hate this thing. Is it really not let you go? Okay, Watson, let's just pick it up here. Watson is a prisoner. Can you see what I'm typing? Kirby?
It stopped after Watson on mine.
Okay, let's see. Can you see it now? Watson is a prisoner?
Oh, yeah.
Okay, I see what it kind of does. Okay, so Watson is a prisoner who is confined at a prison in Northwest Ohio. Some of this I'm making up. You could say proceeding without a lawyer, Watson has filed a civil rights complaint against multiple prison officials, period. Does that show up to you guys? Can you see that?
I can see it.
Okay. Does it cut off where it says multiple?
Yeah.
Okay, sorry. It should say against multiple prison officials. Period. Should be there. This is so terrible, by the way. I mean, this is where, if you guys are having a cocktail, God bless you, because, this is why the class is just, coming off the rails. Okay. But anyway, going back. All right. So, sorry, I had to plug my phone in, or my computer in. Okay. Well, what do I want? We want the thesis at the beginning. You want the 30,000 overview. 30,000 foot overview. So you want to say up front, like, look, he's a prisoner who's confined at this prison. He doesn't have a lawyer. He's filed a civil rights complaint against multiple prison officials. What is he arguing? You want to say something like, Watson is claiming that those officials ran afoul of his rights under the Eighth Amendment. Because, or you could say, by providing him with legally inadequate medical care, period. Okay. Do you see that, Kirby?
Yeah, I can.
Okay, good. All right. So that's like maybe the first part of the thesis. And that might constitute its own paragraph. But all that is doing is getting you kind of oriented. Like if you're just if you're getting into the case, it's getting you set up. So you're like, okay, this is what's going on. There's somebody in prison who's filing a lawsuit, and here's what he's claiming. Now I want you to basically give your answer. You would say up front something like, Watson has failed to state an Eighth Amendment claim, period. And then you want to say why. Now, so that is very much like you saying Maria is a strong candidate for cancellation of removal, right? I mean, that's the analogy there. Or it's me saying you should go to Starbucks instead of Quills. So that's your answer to the whole thing. Now you've got to prove why that is. But remember, we're just in our thesis paragraph. So how do you prove why? Well, you've got to know what the elements are of an Eighth Amendment deliberate indifference claim. Well, what I was saying is on that page, page 2 of the opinion, that fourth paragraph in the analysis, it's not all the way until page 2, right side, second, the column 2, where it says in the context of a claim, you've got to show these two things. So what we know is in order to prove up a deliberate indifference claim, you've got to show that you, the prisoner, if you're a prisoner and you're incarcerated, if you want to say, hey, they inflicted cruel and unusual punishment upon me by not providing me with legally adequate medical care, what you've got to show is, one, you had a sufficiently serious medical need, and two, that prison officials that you're suing displayed a deliberate indifference to that need. Does that make sense? So those are the two things you've got to show. Now, if you can show those things, you get to go move forward with your Eighth Amendment claim. Now, if we're arguing that you've failed to show that you've got a valid Eighth Amendment claim, then you've got to say that both of those elements are not met. So, if in your thesis you say Watson has failed to state an Eighth Amendment claim, you would want to follow that up by saying that is because Watson has not shown that he suffers from a sufficiently serious medical condition, period. Do you see that, Kirby?
Yes, I can.
Okay. And then you could say, do you see why we're doing that? I mean, does it make sense?
Yeah, it does.
Okay. Yeah. So what we're basically saying is, like, another way to say this would be to say, hey, this guy Watson, if he wanted to prove up an Eighth Amendment claim, he's got to meet two elements. The problem is he doesn't meet either one, right? He's not shown he suffers from a sufficiently serious medical condition. Moreover, even if Watson did have a serious medical need, he has not established that any of the prison officials displayed a deliberate indifference to that need, period. And then I would say something like, thus Watson's, I'm just making this up, Eighth Amendment claim, thus Watson has failed to state a viable Eighth Amendment claim. And Now we've all written your thesis together. But it looks something like that, which is really, I'm envisioning your thesis, right? I'm going to try to use this pencil. This is starting to become fun. This is your thesis, right? It's really one kind of little section, but it's probably going to be 2 paragraphs. This is 1 paragraph, just this 30,000 foot overview. And are you seeing me draw on this, Kirby?
Yes, I can.
Okay, good. And then this is the paragraph 2, right? This stuff right here is a paragraph. This right here only serves as a function of like orienting the reader to the case. This is your bottom line up front. Okay. Now, going back, I think it was to Anthony. Anthony, my question to you was, what should come after this thesis? And the answer I wanted was fact section, right? So what you're going to want to include here is just basically a streamlined discussion of the facts. And it's just basically like a narrative about what happened to Watson, right? And there's no like perfect way to do this, right? I mean, conciseness, right? What are some of the things you want to think about? Being concise. You want to try to write it in a clear way. You want to try to use the active voice. A lot of the things that we've talked about throughout the course of the semester. Short sentences that aren't lengthy. You don't really no need to cite the law here for the most part, right? It's just a factual narrative. Like, hey, here's when he first got incarcerated. Here's when he first discovered that he had a skin condition. Here's when he first went to the nurse. Here's what she said. Here's when he went to this other nurse. That's what this guy said. He claims it was getting better, but it wasn't. All until maybe at the end of the facts section, you talk about he files a lawsuit, what he is claiming, and what he is seeking, right? Like a narrative set of facts, and then you might transition over to procedural facts, which is like, he's now filing a lawsuit, he's suing these people, he's claiming that they ran afoul of his 8th Amendment rights, and he's seeking money damages. Does that make sense, Anthony?
Yeah, it does.
Are you able to see what I'm doing on this whiteboard?
Yeah, it does.
Okay, good.
Yeah.
Right. Okay. And then what's after that? Okay, let's stick with you, Anthony. What's after the fact section? What's my second substantive section going to be?
Well, I guess you would be applying the facts to the standard of law. Sorry, let me pull up the opinion.
No, that is my way of being funny, which is my analysis with my smiley face emoji. Yes, that's exactly what it is, right? Like, yeah, that's exactly what we're doing, right? Which is now, can you see my pointer? Like when I move the pointer over the screen, do you see that or no?
No, I don't think so.
Do you see it now?
Yeah, I do see it. Yeah.
Okay. Well, as if this matters, right? I mean, it's like 8:07. Okay, like, is anybody focused? I mean, I'm losing interest. Okay, I don't need to. Here's the thing. Like, do you see this thesis here, right? Or this is the thesis. This 30,000 foot view isn't really going to do us any work. This right here, Anthony, is what we want to use for your analysis section, right? Because this is your 30,000 foot view, not of what's going on factually. Like this factual 30,000 foot view is really where you are getting a sense of what the facts are about. This part of your thesis is really the 30,000 foot view of your analysis. And so what you want to do is basically start back up here. And I almost think you could repeat this. And then you want to kind of break down each of these elements. So what you want to do is I would just copy, I don't know if I would say copy and paste it, but you might say, like, since you're going to say down at the end of your fact section that he's pursuing an 8th Amendment claim, you could say Watson has failed to state a claim under the 8th Amendment, right? And then say that is because of A, right, he hasn't demonstrated that he suffers from a serious medical need, and B, even if he did, he's not shown that prison officials displayed a deliberate indifference to that need. Does that make sense?
Yeah.
Okay, now here's another question. What's going to go after that?
Well, the conclusion.
Well, no. I mean, we're way before the conclusion.
Okay.
Right?
Are you
What's
talking
gonna
about
come-
in that? You're talking about that A subsection. Hello. Hello. I don't know what's
I
happening.
think he got disconnected.
I'm not sure what happened. I don't know what happened.
Dude. I think if you keep clicking.
Oh my god.
It is literally incredible.
Okay.
Yes, we can.
I'm sorry about that. My computer just messed up completely. Okay, sorry about that. I had to and then I went to the Blackboard page and I tried my best to figure out what was going on there, and then I couldn't find anyway, it's a mess. Okay, so everybody's back online and I'm back. Does everybody still see the whiteboard? Can you all see the whiteboard still? Okay, good. Okay. Right, so we've not messed anything up. Okay, look. So we're thinking at the analysis section here. What I wanted to get across is the thesis is going to be the thesis is basically serving two functions. It's going to give you a 30,000-foot factual overview of the case. That's what you want. But it's also giving you a 30,000-foot overview legally of what's going on and what the answer is. And so you've got that there. You do have to, and Anthony pointed this out, or we were discussing it. You're going to have a discussion of your facts, right? And it's a streamlined discussion, a narrative about what happened. It's going to be clear. It's going to be concise. You want to use the active voice. But you want to just, in a very clear way, state factually what happened to this person So you're left with an understanding of what happened and what he's claiming. And you won't really know if you're just looking at the facts whether he has a viable claim or not. It's not until the analysis comes that you're going to go do your bottom line up front in the Eighth Amendment world. But you're going to basically say in your analysis, which is this part, let me see if I can grab the little pointer. It's this part over here. You're going to state basically this part of the thesis up front over here. Okay, so you're going to say Watson has failed to state a claim under the Eighth Amendment. That's because he's not shown that he suffers from a sufficiently serious medical condition. Moreover, even if he did, he has not established that any of the prison officials displayed a deliberate indifference to that need. Let me also just back up. Plain language, what does all that mean? It means that if you're going to be a prisoner and you're going to sue someone or a prison official for running afoul of your Eighth Amendment rights, that means that what you're claiming is that the prisoner was basically committing or was a victim of cruel and unusual punishment, right? That's what you're basically saying. I'm distracted because you may also hear my kids in the background. I think they're having fun. But yeah, what you're basically saying is that the prison official inflicted cruel and unusual punishment on me. So you're saying, like, I had a medical condition, it's a serious medical condition, and they displayed a deliberate indifference to my medical need. They basically knew I had a medical condition and basically flipped me the bird and said, we're not helping you. We're not helping you with your serious medical condition. And what the courts have said is if that's true, if you can show that you really had a serious medical condition and they just displayed a deliberate indifference to that, they didn't give a crap about that, maybe, just maybe, that could give rise to an Eighth Amendment claim of cruel and unusual punishment. And an example of that might be something like, hey, I've got diabetes, I've got a serious medical condition, I specifically and repeatedly asked for my diabetes medication, I asked for my insulin, and the prison officials said, we're not giving you your insulin because we don't like you. Or we don't, or we're racist, or we're, sexist, or, using some sort of terrible discriminatory reason. That could absolutely give rise to an Eighth Amendment claim if those were the facts. Because you would have a sufficiently serious medical need, and you would not really only have a deliberate indifference to that, but you would also have just a terrible, unconstitutional reason for denying somebody their medical care, the care that they need. So that would give rise to cruel and unusual punishment. Here, though, if you read over the facts, I think you've got a narrative that suggests that, under the law, it's questionable about whether or not his medical condition would be viewed as sufficiently serious. But it seems like it would probably fall under the not so serious side. But even if it did, and you were wrong about that, it doesn't seem like the facts that he's alleged show that the defendants displayed a deliberate indifference to that. If anything, it suggests that they kind of knew about his condition, provided him some sort of treatment, creams, a shampoo, different things he could try, and maybe they just didn't work. And not being great at providing care or providing care that didn't really fix the problem, that's not, at least what the law viewed as deliberate indifference, that's potentially negligence. But that's a much lower standard. So that's the background. But the point here is in drafting this, you want to basically state your bottom line up front. And then I think I left off with you, Anthony. What are we going to put down here as I point to the whiteboard? What are we going to put after we lay out our answer? Because all this, Anthony, is your bottom line up front. It's just your answer to the overarching question, but you have to analyze why each of these elements are the way they are. So what's your next paragraph going to be here under the analysis? Anthony, what do you think?
If I'm understanding your question correctly, I think you would be just basically going into the facts that support your decision for each element in their own paragraphs, essentially.
Yeah, I mean, I think we're saying the same thing. I mean, what I'm thinking here is, let me go back to my text box. I think I cut out too. Can you see me again? My internet seems like it's, can you see me?
You're like in a very small frame. I'm still looking at the whiteboard mainly.
Well, that's okay. That's good. As long as you can see me some, and you can see the whiteboard, that's all that matters. Okay. So it says Watson has failed to state a claim. That's because A, he's not shown that he suffers from a sufficiently serious medical need. Moreover, even if he did suffer from a sufficiently serious medical need, he's not established that any of the prison officials displayed a deliberate indifference to that need. The next thing you're going to want down here is something like, first, Watson has not shown that he suffers from a sufficiently serious medical need. This down here is going to be the start of a new paragraph, right? This is a paragraph. This is your, I'm trying to write with this, bottom line up front. And it's got basically two elements. And then this is your first proof-like paragraph about this first element. Does that make sense?
Yeah.
Okay. I mean, it's basically like the same thing with the other email that you did, right? It's like the only difference with the email was you didn't really have this, and you didn't really need this because I told you not to include it. But really, this was the same. The only difference was here in Maria's case, you were saying, instead of Watson has failed to state an Eighth Amendment claim, you were saying Maria is a strong candidate for cancellation of removal. That's because she meets the four elements, first, second, third, fourth. And then you jumped straight to the analysis because I told you to skip the facts. So when you jump to the analysis, you just said Maria has a strong claim. That's because she meets 1, 2, 3, and 4. And then who was helping me with that? It was maybe Alexander, I think. And we were going, element by element. And he said, I had like little subsections. You could totally do that here, Alexander, too, if you wanted. Like here, if you wanted to do, what would be your heading look like here, Alexander? What do you think?
On which one?
I'm down here. What would your heading be? What would I just crossed it out, but what would this be? Remember you and I were talking about headings? And I'm basically saying you kicked butt on that. Like that was exactly what I wanted from you, which is like headings. That makes sense to me to totally include headings there. So if you want to include a heading in this opinion, what would your heading be?
I mean, I think it would look a lot like that circled section down there. Or you could shorten it up and say something to the effect about, serious medical need.
Yeah. I'm hoping that this, I don't know. I'm hoping it makes more sense when you guys go back and look at the opinion, and see kind of how it's structured. I mean, of course, it's all just, we're taking our first stab at this. I'm trying to get across this kind of big picture view. Let me see if I can move away from the screen here. How do I add whiteboard? Does anybody know? I mean, I'm not doing a good job. I feel bad. I feel like I'm not doing a good job tonight. Let me see if I can expand the whiteboard a little bit. Does anybody know how I make the whiteboard bigger? I should know this. No. Oh. Well, I just went away. Anyway, let's go back just to like where you could see me in a larger format. I feel bad. My connection died, and then I don't know. Let's see. Hold on one second. How do I go away from my whiteboard? I don't need the whiteboard anymore. Is it this? Stop sharing. Can you guys just see me like normal now? Okay. All right. I mean, here's what I'm trying to get across. Let me see if I can just explain it better. You want your thesis. You want the 30,000 foot overview. You want your 30,000 overfoot view of the law. And then you're going to want a fact section. But then after that, you're going to go into your analysis section. And this whole thing may seem lengthy and complicated. I think what you'll see is most of the opinion you can completely cut out. You don't need a standard overview section. You don't need huge blocks of law. This whole case is about a guy who's incarcerated. He's suing a bunch of prison officials, and he's saying, hey, they ran afoul of my Eighth Amendment rights. They inflicted cruel and unusual punishment on me because they didn't provide me with legally adequate medical care. He's saying, look at what they did. He's saying, one, I had a sufficiently serious medical need, this skin condition. And he's saying, two, they displayed a deliberate indifference to that need. The problem with that is he's kind of wrong on both of those things. He didn't have a serious medical need. And even if he did, they didn't display deliberate indifference to him based on the facts. So what you want to do is just basically say that up front. Hey, this at the very beginning in your thesis, this is a guy who's a prisoner. He's incarcerated in northern Ohio. He's suing a bunch of prison officials, and he's saying they displayed a deliberate indifference to their need, to his medical need, and therefore ran afoul of his Eighth Amendment rights. However, he's failed to state an Eighth Amendment claim. That's because he didn't have a sufficiently serious medical need, and even if he did, they didn't display deliberate indifference to him. Facts section, lay that out, both facts and procedural facts, and then go to an analysis section. Bottom line up front. He's failed to state an Eighth Amendment claim. That's because of the two things. One, he hasn't demonstrated a sufficiently serious medical need, and even if he did, he's failed to show that they displayed a deliberate indifference. Next paragraph, he's failed to show that he had a serious medical need. And you explain what that means. This goes back to my discussion with Alexander, and I think the other students as well. You might have to expand a little bit on what the meaning of that phrase is. What does a sufficiently serious medical need mean? So you might have to pull a little bit of law down that says, under the law, this is how it's been defined and applied to these facts. Here's why his condition doesn't meet it, and then come to a conclusion. And then you'll go to the next element, which is, however, even if he did have a sufficiently serious medical need, he hasn't shown that the defendants, the prison officials, displayed a deliberate indifference to that need. Again, you might have to explain a little bit about what deliberate indifference means, but you'll go through that and you'll want to kind of discuss the facts that are relevant and explain like, hey, these are all of the things under the facts that the defendants, that the prison officials did to provide him with care. And when you get a bunch of medical care, that's not cruel and unusual punishment. That may be shitty medical care, right? It may be not so great medical care. It might even be negligence. It might even constitute medical malpractice, potentially, which is a whole separate cause of action. But it doesn't rise to the level of cruel and unusual punishment. I mean, it's a very serious thing. Cruel and unusual punishment is an extremely high bar. I mean, think about it this way. The Supreme Court has said the death penalty does not constitute cruel and unusual punishment. So it's a high bar. And certainly receiving medical care as a general matter doesn't meet that. And so because of that, the plaintiff doesn't satisfy his cause of action. And so you'll just want to say that. So I did a poor job today. I feel bad. The whiteboard didn't work well. My connection cut out. But I hope you'll give me a mulligan on that one. Does anybody have any questions about that? So what are we supposed to be doing for next class? Well, what I want you to do is read over that short article on judicial opinions, read over the case, the Watson case, and take it out. And I would start by just heavily editing it with a pencil, but do so thinking like, I'm going to rewrite this thing. I'm not just going to turn in like edits. I'm going to turn in like a total rewrite. Now, when I say total rewrite, I don't mean that this should take you hours on end. It absolutely should not. I mean, in a way, we kind of already got halfway there just based on what I could squeeze onto that whiteboard. But it really should just be something that you can kind of get in and get out and use the opinion. It does have a lot of good resources in the sense that it has a lot of things you could pull from there and include in your opinion, but it'll be much, much, much more streamlined so that it maybe is a page or 2 pages as opposed to 4 pages of single space columns. It's way too long. I think that's enough. 8:30. Did you guys, does anybody have a question or a comment or a concern? Raise your hand if it wasn't a total disaster tonight. If the class was not a total, all right. So not a total disaster. That's something. I felt like it was a disaster. At one point, I just felt like it was going off the rails. Okay. Some of you didn't raise your hand, so maybe it was a total disaster. But anyway, all right, let's just end the class. I'll stick around for a couple more minutes if somebody wants to chat or it's a question. Otherwise, you can take a stab at the assignment. It's a super soft deadline Saturday at 5. If you get it done, great. If you need some extra time, couple days, whatever, it's totally fine. I hope everybody stays well, stays healthy. That's the most important thing. Has a great week. And I look forward to seeing you next week. Hopefully, I'll do a little bit of a better job. Take care, guys. Have a good one.